When the first Congress met in 1789 under the new Constitution, James Madison undertook the responsibility of drafting the amendments that were to become the Bill of Rights, even though he had originally opposed inclusion of a Bill of Rights. You will recall that Madison had opposed inclusion of a Bill of Rights in the Constitution, in part because he worried about a restrictive interpretation of individual rights. I'll invite you to consider the language of the Ninth Amendment on your own to determine how Madison might have reconciled his concerns. Let's turn our attention to a broader issue. Recall the First Amendment begins with the phrase, "Congress shall make no law." Originally, the Bill of Rights applied only to the federal government and not to the several state governments. Parts of the amendments initially proposed by Madison would have limited state governments, but they were not approved by Congress, and therefore the Bill of Rights did not appear to apply to the powers of the state governments. As a result, a number of states had established state churches up until the 1820s, and southern states, beginning in the 1830s, could ban abolitionist literature. In the 1833 case, Barron v. Baltimore, the Supreme Court specifically ruled that the Bill of Rights provided, quote, security against the encroachments of the general government, not against those of local governments. However, today, Americans assume that the Bill of Rights protects their fundamental liberties, such as the right of free speech or the right of free worship, against state governments as well. Is this assumption valid? It is, at least in many instances. How do we move from the original intent of the Bill of Rights limiting the power of the national government to an understanding that it limits governmental authority at all levels? In the 1925 judgment on Gitlow v. New York, the Supreme Court ruled that the Due Process Clause of the 14th Amendment, which had been adopted in 1868 in the wake of the Civil War, made certain provisions of the Bill of Rights applicable to the states. The 14th Amendment had been added to the Constitution in an effort to ensure that the states would not deny the former slaves full citizenship rights. The language of the 14th Amendment indicates, "Nor shall any state deprive any person of life, liberty, or property without due process of law." The question for the court has been, what does the concept of liberty incorporate? Does it incorporate the freedom of speech? Does it incorporate the right of free worship? The court has determined that the answer in each of these areas is yes. The Supreme Court has subsequently cited the Gitlow case as precedent for a series of decisions that made most of the provisions of the Bill of Rights applicable to the states. However, there are a few provisions of the Bill of Rights that the court has not incorporated into the Due Process Clause of the 14th Amendment, such as the right to keep and bear arms in the Second Amendment, or the right to indictment by grand jury in the Eighth Amendment. This very critical principle of American constitutional law is known as the doctrine of selective incorporation.